Chairman Good, Ranking Member Delie, and members of the subcommittee, good morning and thank you for having me. My name is Steve Delie, and I'm Director of Labor Policy for the Mackinac Center, a 501c3 research and educational organization that advances the cause of free markets and limited government. I'm here today to support policies that will better enable workers to make a free choice about unionization in the workplace. These policies are necessary because the current administration, including the National Labor Relations Board under Chairman Lauren McFerrin, have encouraged the adoption of policies that favor unions over workers. Today, I would like to discuss those policies as well as three bills that advance the cause of worker freedom, namely the Employee Rights Act, the Workers' Choice Act, and the Start Applying Labor Transparency Act. For decades, unions have been aggressively pursuing an organizing strategy based on a process known as card check, which is an alternative to the traditional secret ballot election. Secret ballot elections are the gold standard for unionization determinations, and both the NLRB and courts have recognized as such. Despite this, unions have aggressively pushed for card check. Card check occurs in public, which itself puts undue pressure on employees. While this pressure alone is a problem, a far more troubling issue is that card check campaigns open the door to deception and coercion. Past union tactics have included threats of violence, deportation, and even lying about the effect of signing a card. Whether it be through deception, coercion, or pressure, card check campaigns necessarily distort employees' true opinions about unionization. One technique unions use to avoid secret ballot elections is to convince or to coerce employers into entering into so-called neutrality agreements. Although styled as an agreement by an employer to maintain neutrality throughout a unionization campaign, these agreements silence employers and deprive employees from hearing all of the facts regarding unionization. To obtain neutrality agreements, unions often turn to a tool known as a corporate campaign. A corporate campaign occurs when a union attempts to accomplish labor goals through economic or legal pressure. In some cases, corporate campaigns have even caused businesses to close entirely, an outcome that has been praised by union organizers. Shutting down a business as a message to other non-union businesses might be a win for unions, but it does little to help the workers who end up unemployed. Another example of the unfair playing field in labor law is known as salting. Salting is the union practice of hiring workers to create discontent amongst employees while encouraging unionization. And while employers are required to file detailed reports on their consultants, unions are not. Congress should level the playing field. Workers' rights to a fair election are under threat. The most significant legislative threat to the secret ballot is the PRO Act. Under the PRO Act, employers accused of interfering in an election must prove their innocence or risk being ordered to bargain based on card check. This is particularly problematic thanks to the NLRB's recent decision in Cemex. The ongoing attacks against workers' rights to a free and fair election have not gone unnoticed. Ongoing efforts at both the federal and state levels are advancing the cause of worker freedom. At the federal level, the Employee Rights Act, the Workers' Choice Act, and the SALT Act are all meaningful steps towards ensuring workers have a free and fair choice about unionization. While the ERA advances several policies, the most relevant to my testimony today is its guarantee of a secret ballot election. The Workers' Choice Act ensures that workers opting out of union membership have the chance to represent themselves in employment matters. The SALT Act, meanwhile, ensures that unions and employers are treated equally. I urge the passage of all three acts, which, together, will eliminate many of the concerns that I've identified today. The states have also recognized the importance of ensuring workers can make a fully informed choice about unionization. In 2023, Tennessee became the first state in the nation to adopt a law requiring secret ballot elections as a condition of economic development funding, with both Georgia and Alabama quickly following suit. These states are at the forefront of pushing back against federal overreach and are ensuring workers can make a fully informed decision about unionization. Congress should heed this growing chorus of state voices and enact common sense reforms to protect workers. The Employee Rights Act, Workers' Choice Act, and SALT Act are all significant steps in the right direction and should be adopted. But Congress can and should go further and ensure that labor law as a whole is premised on the principle of truly voluntary association. I thank you for the opportunity to testify before you today, and I look forward to answering your questions.